The following program is presented by the Metropolitan Library Service Agency.
Hello, welcome to All About Kids, a program focusing on the interests of children and young people and some of the issues affecting them. Our topic today is juvenile justice. Our guests are Isabel Gomez, Chief Judge of the Hennepin County Juvenile Court, and State Senator Allan, Chair of the Senate Judiciary Committee. Their interest in this issue stems from expertise, from long involvement in helping the system respond better to meeting the juvenile justice needs of our young people.
Judge Gomez, Senator Spear, it's a pleasure to have you both on the program today, and I think we've got a topic that could take hours to discuss. We'll just touch the surface. And juvenile justice, I think, is an issue that, depending on where you're looking at it, is either from the punishment punitive point of view or it's from a rehabilitation point of view. You as the legislator certainly probably have some strong philosophies about the kind of laws you're helping implement. So let's just start off by, I'd like your observations on what things in society do you observe now that maybe are forcing some changes with the way we treat young offenders or the way maybe we should treat them. Just your observations. Judge Gomez?
Well, I think it's certainly been noticed fairly recently, because I think there was quite a bit of denial about this in Minnesota, that we really do have an increase in violent behavior among kids. The number of arrests of kids is flat, although the number of children has declined. So against demographics, arrests are up. But that's not so significant as the fact that more kids are coming in on more violent offenses. And you're right, that certainly raises the ante and gets the public much more interested and concerned about what our response is going to be to that. We're also seeing, as a trend, kids coming in younger and younger. And that, I think, really puts the juvenile court and the juvenile system to a test, because it's obvious that we really then do have to make our best efforts at rehabilitation, and also concern ourselves with public safety. If we have a child who's 10 and committing criminal sexual conduct in the first degree, this is obviously a first-order challenge, and we have more and more of those kids.
But then don't we as a society need to wonder what is happening to these children before they get to that point?
Yeah, I think
what's making them commit these sort of horrible permanent crimes?
Well, I think what I see is what I've seen in adult offenders as well. And with adult offenders, it's not as relevant because we've made a societal decision that we're going to punish adult offenders rather than making very extensive efforts at rehabilitation. So we don't really know too much about what would work rehabilitatively with adults. What we know is that, is that everybody I have seen in about 15 years of involvement in criminal justice who has seriously hurt or killed someone else had a history of childhood abuse. I have, at this point, 2 exceptions on my list. I've never had more than 3 at any given time, and I make it sort of a hobby to try to find out about the people that I'm not sure of. Right now there's 1 child and 1 adult for whom, in my history of 15 years, for whom I could not document that childhood abuse. And I think that's very important because it suggests how we might impact the level of violence in our society.
Well, I think one thing we have to keep in mind is that the work that Judge Gomez and the other juvenile court justices do includes both a criminal and a civil side, just like our adult courts do. And a lot of the civil work they do is very much related to what we're just talking about, because they're dealing with what we call CHIPs, children in need of protection, and they're talking about placing kids who are in unstable families or dysfunctional families. And it seems to me that there has to be a great deal of attention paid not just to what we do with kids after they offend, but what we do with kids before they offend, and what we do with kids who we identify as at-risk kids, kids who are in dysfunctional families, kids who have to be removed from families. And that was why we recognized in the crime bill that we passed in the 1992 legislative session that we have to deal not just with punishment, but we have to deal with prevention. And that bill contains within it a large number of programs that are aimed at intervening early and trying to get kids started on the right track before they do offend. And so I agree with everything that Judge Gomez said about the crimes becoming more violent, committed at an early age, the relationship between abuse and offense. And if you want to break that cycle, you're not going to break the cycle just by dealing with a kid who has already committed a serious offense. You have to start before that.
I think it was kind of astonishing. You are considered a legislative leader, in fact, identified as one of the 10 best legislators by Law and Politics, but you're not seen as a child advocate, but yet as chair of the Senate Judiciary Committee, you really assumed an amazing leadership role in
Well, I'd like
pushing
to
that
see
through.
myself
It
as
was
a child advocate.
bipartisan.
I would consider myself a child advocate.
I would stand with Senator Spear as one of the most important advocates kids have in Minnesota. I think that the importance of the kinds of choices the legislature made this year to reduce crime or to deal with law and order. I think the importance of those choices has really not been sufficiently noticed. I think it's a landmark achievement for a legislative body starting without necessarily a lot of knowledge or factual information about these issues that we're talking about, to do the learning that it did, to do the study that it has done over the years under the leadership of people like Senator Spear, and to come up with such a complex response to what is a tremendously complex problem, not to simplify it, and to begin to lay out a course that I think if we commit to will make a real difference in our society. So,
well, and as you indicated, it was a bipartisan effort.
It really was. It was a
aisle.
bipartisan effort. What happened was that in the summer of 1991, there were, as most people will recall, some very, very shocking crimes that were committed in the state. Several murders of young women, sexual assaults and murders. And we began looking at this entire question of how to respond to this. And I think that people initially, after those kinds of things happen, say, lock them up, throw the key away, make sure that these people never get out again. Now, we did do some of that. And I believe that there are people in this society who have been repeat offenders, who have a pattern of this kind of offense, for whom the possibilities of rehabilitation are not very great, whom we just have to keep in prison for a very long time. And we did do that. But we also recognized that there were that this was more complex than just that, and that the responses needed to be more comprehensive than that. And so we also did include these prevention measures. We included also a lot of emphasis on victim services, because victims of these kinds of crimes need help. And we put more money into advocates for battered women, advocates for victims of sexual abuse, and advocates for general crime victims, because we felt that that was all very important. One thing that's, I think that's a component of the legislative response is that in some ways, I think we did the right thing. I think one of the things that was helping us, nudging us to do the right thing, was the fact that we have a tight budget. And you might think that's a strange thing to say, that we put money into social programs and prevention programs because our budget was tight, but I don't think it is strange, because I think when we look at other states and the approach that many other states in this country are taking, what we see is an enormous percentage of the state budget going into building and maintaining prisons. That is the most expensive approach you can take to the problem. To spend tens and hundreds of millions of dollars to build the prisons, and then to keep people in prison at $20,000 to $30,000 a year. Prevention is, in the long run, a more cost-effective way. as well as being the more sensible way to approach the problem of crime in our society.
From your point of view on the bench, what do you see happening to some of these children coming before you? Are you frustrated at some of the things that are going on in the system, even though we've got some enlightened legislation now?
Oh, I'm extremely frustrated. I have enough frustrations to, since I'm a person who refuses to allow frustration without action to relieve it, I've got enough frustrations to keep me busy until I'm 100, I'm sure. We have our system of juvenile justice, including the dependency neglect areas in Minnesota, has a lot of peculiarities. It is quite eccentric in some ways. And I think partly that results from the extreme privacy of our systems. There are some states, particularly Western states, that have a juvenile justice system that's much more open. I think some of your viewers might be surprised to learn that juvenile records of the juvenile court are private records, that they could not attend our hearings for the most part, even if they wanted to.
So the children who are being discussed, the very kids whose lives are being affected by your decisions, even if they are old enough to have an idea of what might be going on, can't come?
That's true. And the result, I think what's really important there are a lot of things that follow from that. One is that people simply don't know the facts. Do not know, for example, that kids commit the amount of crime that they do. I have succeeded in getting Hennepin County Planning to break out crime statistics in terms of age. And if you look at 1991 statistics, which are the first ones that have been done that way, I think you're going to be surprised at the quantity of felonies that are committed by kids. Kids in 1990, at the end of, in 1991, committed 20 to 25% of the homicides in Hennepin County, committed 40% or so of the burglaries, 65% of the auto thefts. And you understand, we're only talking about kids who can't be younger than 10. So we're talking about kids from 10 to 18. And really, we're talking about kids from about 13, 12 maybe, to 18, although increasingly we're getting younger and younger kids. People just don't know the facts. And
what do you do when a child who's 10 or 11 appears before you and has committed a violent crime, perhaps murder or armed robbery or something? How do you handle that child?
Very carefully. We do essentially a sort of hand-tailored assessment, including psychological, psychiatric, neurological measures of the child. We find out everything we can about family history. We find out everything we can about the crime. We try to understand this child, and then what I've hoped to do during the time I've been in juvenile court is to begin to change the question we ask once we have that information. I think the question has tended to be, historically, what do we do with the body today? By analogy to adult criminal courts. So, you've got somebody, you've got to do something with him. Well, of course, we do have to do something with him. But if he's 10 years old and he has committed criminal sexual conduct in the first degree, what we do with him had better be the right thing. And so the questions I think we need to ask are, what caused this child's behavior? What issues can be dealt with therapeutically? What setting should we use? How long will it take? How much will it cost? Will we make that commitment to that child? So that we're trying to get to a point where we make one good effort with
looking
the kid.
At the whole picture, the whole child.
And so with a child like that, we usually go, the kid, a 10 or 11-year-old who's that damaged is usually very volatile, tends to run, has often had virtually no contact with rational adults. We usually have to start with a lock setting, a treatment setting. We have a couple of facilities that have a few beds for boys that age. And as the kids get more stable and as they get healthier and establish some kind of trust with the people they're working with, gradually move them into more open settings. And commit increasingly to working with that kid for a minimum of 3 years and maybe all the way up to 8 or 9 years. So it's not a small matter.
I'd like to say something about the issue of the records and the fact that juvenile court records and juvenile court proceedings are closed to the general public. That really flows out of ideas about the nature of juvenile court. When juvenile courts were first established back in the early years of the 20th century, the whole idea was that kids should be treated differently from adults, and that kids should be given a second chance, and there should be a more conciliatory and less adversarial approach. And I think there were good intentions behind the notion
Certainly.
of closing records and closing proceedings so that you won't stigmatize kids for the rest of their life. You're going to give them a chance to rehabilitate, and then these childhood misdeeds will, in a sense, be wiped away, and they'll get to start with a fresh slate. There has been in recent years a good deal of talk about, at least in the more serious cases, of opening records, letting those records follow the child into adulthood so that they would be used in compiling criminal history scores in case of later offenses as adults. I think if we do that, I think we have to keep in mind, though, and there may be some good reasons to do that, that we're also then probably going to narrow the gap in other ways between juvenile and adult court. If, for example, and we discussed this in the 1992 legislative session, if, for example, we're going to allow criminal history scores to be, juvenile records to remain as part of the person's record when they go into adulthood, then it seems to me that we probably are also going to move toward a more adversarial kind of system in juvenile court with things like counsel for everybody, which I think you do have in most cases in Hennepin County, but which is not true everywhere in the state. Jury trials, which we don't have in juvenile court. Because if this is going to be...
society, people would be outraged to see a 10 or 12-year-old on the stand with a jury?
Well, 10 and 12-year-olds are on the stand now with a jury when they're witnesses.
That's right.
Or when they're victims.
I think that that's a very important question because it really does point up how peculiar our court is. I mean, Senator Spear is right in outlining the history. The court started out in 1900 or so, juvenile courts pretty much as social service agencies. Now they are clearly courts. We follow criminal rules in some cases and civil rules in others. We have lawyers in every case. We have court reporters, we have judges, we have all of the accoutrements of a court, and we must follow the due process rules of courts. And the subject matter that we cover is tremendously important. I have the authority in my court to send a child to Colorado and say he can't come back until he's 19 years old. I can remove children from their parents' custody, and I can order the spending. Our court last year directly ordered the spending of more than $200 million. And we are completely unaccountable. Now, I think that's peculiar in a democracy.
That would be for rehabilitation for these children, for treatment
well, and
programs.
Looking at a lot of it in out-of-home placements for children in neglect and abuse cases. Not only are we not accountable, that is the judges, the only time I as a judge can order anybody, the Bureau of Social Services, for example, to pay for somebody's rehabilitation is in juvenile court. In adult court, if I see an adult who I think has a chemical dependency problem, I can order him to be assessed by the person who the state has said is the doorkeeper to services. I can't just stick him into services whether I'm right or wrong about my judgment. And I really think in a democracy, questions of this order probably would be better answered if we had more people asking us questions, if we had more people giving us ideas, if we were able to turn more directly to other professionals in other areas and collaborate with them to achieve better results. Right now, the privacy barriers, not only between the court and the public, but between the court and the schools, between social services and corrections. Actually, the legislature helped us take that wall down. Those kinds of barriers really, I think, are meaning that we're not getting a bang for our buck that we ought to be getting, but more than that, we aren't doing as well
We're losing children.
in this work. That
Senator, you're going to take that on next session?
Well,
try
I
to
mean,
get
we
some of
haven't.
these changes?
It's not a question of taking this on in a one-shot deal.
No.
We have been dealing with juvenile court issues for a number of years now at the legislature. Back in 1987, we had a proposal for what would have been a massive reform of the juvenile court system, which we did not pass. It was too much all at once for the legislature, and I think for the system to really deal with and really confront. But I think we are continually looking at this process. Now, one thing I was going to mention that I think probably should be at least alluded to, especially when we're talking about the more serious offenders, is the certification process, which is being used more and more in this state. This is the process where an older juvenile who has committed a serious offense can be certified for trial as an adult. And essentially, in those cases, the juvenile court system is bypassed. And so with the 16 and 17-year-olds in particular who are committing murder or committing sexual assault, some of the more violent crimes, many of them are being certified, tried as adults, and they're being sent to adult correctional institutions.
And from my standpoint, that is a tragic loss of an opportunity for us to address a person who is certainly going to be extraordinarily dangerous if we are not able to get him
because once that child
changed.
gets into the adult correctional system, there is not much opportunity for rehabilitation
I don't
or
think
dealing
there
with
is.
the problems.
There's a clear there's an argument about this, and certainly the Commissioner of Corrections would take a very different view. He believes very strongly that St. Cloud, for example, which houses our younger male adult offenders and these certified boys, that St. Cloud is a rehabilitative institution. I don't believe it is, and I don't believe it's safe. That's something
Well,
that
do you think people are
somebody
afraid,
else
though,
is going to have to...
someone turns on the 10 o'clock news and sees that some 16-year-old has murdered a couple of people in a convenience store?
Of course they
and the immediate reaction is lock them up, take them away.
Well, and I think one of the problems in those kinds of cases, one of the things the public is outraged about, if those kids are then tried as juveniles, that the juvenile court then only has jurisdiction over them until they're 19, and then that's it. And so these kid who's 16 or 17 might only serve 2 or 3 years.
And that's not adequate.
And that's simply not adequate.
I had a case recently where a child who was 17, or boy who was 17, very badly hurt someone. And it was a case that really put us to it in terms of these choices. He's a boy who was is not very bright, had not had any juvenile history to speak of, just a shoplift, and looked really rehabilitatable. Everybody who examined him thought that there were issues that could be dealt with. But I could not look at if I were forced to say either this boy who will be who has essentially destroyed the brain of an adult, of a man, did it with one punch and did not, I'm sure, intend any such outcome, but that was the outcome. His victim is in a coma and probably will never emerge from one because of the damage he suffered when his head hit the sidewalk. In that case, if I have to look at the public and say, my response to this is that, to this unprovoked attack, is that a 17-and-a-half-year-old who did it will be in a juvenile institution for 1.5 years and then will say goodbye, I think that would just be a clear dereliction of duty. I couldn't do that. On the other hand, if I say, this is a person who everybody thinks we've got more than a 50-50 shot with, because his behavior was not that aberrant. I mean, he punched somebody. And because there are clear issues and things that he has to learn, and we know what they are, and we're not going to do that. We're not going to try to do that. We're just going to send him to St. Cloud, where, given his low IQ, his suggestibility, his extreme immaturity, he is going to have to coast on his reputation as somebody who almost kills someone in order to survive. And by the time he gets out, will be a person who is very likely to hurt someone again. That doesn't seem okay either. We were able in that case to arrive at a compromise which involved a 10-year, which involved my sentencing him on the adult first-degree assault for a 10-year probationary period and 86 months in the custody of the Commissioner of Corrections in the adult system, and staying that sentence on the condition that he successfully complete juvenile probation and successfully complete a very carefully planned probation plan, which we have for him as an adult. We have a new unit, this is good news really, a new unit in Hennepin County of probation officers who will specialize with certified kids and with these young offenders so that they get a lot more intensive probation than adults because they are reachable and you can mold them and shape them to some extent. What we have to figure out, it's not clear, whether this kind of approach, which is just stuck together with spit and glue, is really the right approach. What we do have to talk about on the state level is is there a way that we could deal with youthful offenders to maximize the chances that they will be rehabilitated and still protect the public safety, and how do we devise mechanisms?
Well, we have been talking about it. It's just that we haven't reached any conclusions.
Right.
And many of the things that Judge Gomez has been referring to have been part of an ongoing debate that's been going on in the legislature for a number of years. For example, should we extend the jurisdiction of the juvenile court beyond the age of 19 versus the use of certification? That's one pair of options. If we were to extend the jurisdiction of juvenile court, then that would strengthen the case for having a state secure facility for juveniles, which we don't have now. So instead of sending these kids, certifying these kids and sending them to St. Cloud, we would be trying them as juveniles, extending the jurisdiction of the juvenile court and putting them in a juvenile facility. What we did in the 1992 legislative session, when we really couldn't reach conclusions on some of these questions, was to establish an advisory task force on juvenile justice. And they are being asked to look at this question. They're going to be looking at the question of records, of opening proceedings, that whole range of issues that involve the criminal side of what the juvenile court does. And this commission will involve
legislators, it will involve
it involves,
justices,
yes, the
social workers.
The appointments are divided between the governor, the legislative leadership, and the Chief Justice of the Supreme Court. So the Chief Justice will appoint, and is in the process now of appointing judges and some law professors. There will be several legislators on there, and there will be some citizens who will be appointed by the governor.
Will you come back and talk about this next year? Our time is up and we didn't even get started talking.
Thanks.
Thank you both very much. Thank you, Judge Gomez and Senator Speer, for those thoughtful insights on juvenile justice, a topic which certainly has crucial importance in today's society. Thanks to all of you for joining us on All About Kids. Please tune in again.
This has been a presentation of Hennepin County Library in conjunction with the Twin Cities Metropolitan Library Service Agency. We thank you for watching, and we hope you visit your public library often.